Welcome, everybody. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy, and I'd like to welcome you to today's event, Judging Juries, Examining Jury Engagement and Exclusion. And I would like to say this is a particularly splendid place to have such a program. And for those of you who may not be familiar with ACS, we are a national network of lawyers and law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. And we work for positive change by shaping debate on vitally important legal and constitutional issues through development and promotion of high-impact ideas. Now, approximately 32 million Americans receive a jury summons every year. There may be no more dreaded piece of mail. To say that Americans despise this civic duty may actually be an understatement. But clearly our founding fathers felt differently. Indeed, they felt so strongly about the right to a jury trial that is in both the Constitution's articles and in the Bill of Rights. And the Supreme Court has also demonstrated respect for this constitutional guarantee, most often in the context of the Sixth Amendment. Recently, in 2008, in Snyder versus Louisiana, the court reaffirmed the decision in Batson versus Kentucky, holding that race should not be a factor in jury selection. And the court has made clear that biases based on race and other factors prevent full jury participation that is indeed required by our Constitution. So both the Constitution and the Supreme Court suggest that the jury trial is a centerpiece of our justice system. So why do contemporary attitudes towards jury service suggest the contrary? Today we will explore this question and others. We will discuss efforts to improve our jury systems and consider how we will live up to the ideal of having a jury of one's peers. To start the conversation, we are honored to have Judge Richard Urbina. Judge Urbina has served on the U.S. District Court for the District of Columbia since 1994, having previously served on the Superior Court of the District of Columbia for 13 years. Prior to sitting on the bench, Judge Urbina was a staff attorney for the renowned D.C. Public Defender Service and was on the faculty at Howard University Law School, where he directed the university's criminal justice program. Justice Urbina currently teaches a class on the American jury at George Washington University Law School. We could not have a better speaker today to introduce this discussion. So please join me in welcoming Judge Urbina. Thank you.
Well, as I look out at the audience, I see people out there who are more expert than the speaker. So let me try to get at the subject matter so we can get to the part of the program that involves the panel and questions and answers. The jury, first of all, let me say that I am speaking from the perspective primarily of a judge, since I've been a sitting judge for almost 31 years. And therefore, my view of the jury is highly influenced by the experiences that I've had. So let me start by saying that I believe the American jury is one of the greatest engines for justice one can ever imagine. This is after having presided over many, many jury trials and having verdicts rendered, the vast majority of which I agree with. The control of power was one of the main reasons why the English and then the American justice system decided that it would include as a component citizens, people from the community who would join together and listen to the presentation of evidence and render a decision. And I think nowadays it's rather important to keep that original motivation in mind. Specifically, it was an effort to control the power of the executive. When the United States was still a young baby country and these great people we call our founding fathers came together, they had many, many disagreements, and as you know, Jefferson and Hamilton, for example, agreed on very little, but both of them agreed that the American jury system needed to be a component in order to achieve a number of things. Some people during that period thought that once we get rid of these English judges or judges that are transplants from England who are obedient to the crown as opposed to the American executive, that once we got rid of those judges, that they could be replaced by competent, honorable people who would be able to respond appropriately to controversies, and therefore perhaps there was no need for a jury. But this premise was quickly and thoroughly rejected, in that there had been some rather bad experiences left over from English rule, and it was clear to many people that one needed a buffer, a filter, a force to ensure that decisions coming from on high, from the executive or other branches of government, could be checked, could be screened, and could be monitored for fairness. And so the American jury evolved from a very early stage as a body that was supposed to present the system with a surefire way of filtering and controlling the imposition of the will of the executive in particular. May I have some water? You have some water? Now, much has been made over the course of years, although the controversy is pretty much resolved by this point as to what it means to have a jury of your peers. And maybe our visitors in the back are as curious as most Americans are in understanding precisely what that means. Thank you. In fact, that issue of jury of your peers has come up repeatedly over time, and my reading tells me that there was even a time here in the United States when there was serious consideration given to the notion of picking what they would call blue ribbon juries, juries that would be better educated than the average person, who were capable in the eyes of some, more capable in the eyes of some, to manage, understand, and resolve complex disputes. But this notion was flatly rejected, because once again, the idea being that once you start turning over this power to an elite group, that power in and of itself needs to be checked, and what was wanted was a cross-section of people from the community that the controversy arose in, so that you would have a merging, a blending of minds and points of view, true diversity, so to speak, in the decision-making process. Now, there are a number of things that we could speak about, but given my limited time, this is what I will try to address. Much has been said about the attitudes of jurors, that is, the attitudes of people who receive summonses and often fail to respond, in fact, throw them in the trash and ignore the summon to come to court and to participate in this extraordinarily important manifestation of democracy. And Washington, D.C. is no exception. If anything, it has an added quality of indifference and apathy, I think, which is explained in a number of ways. The District of Columbia has two complete court systems, two totally comprehensive court systems, the city's court system, the Superior Court, and the federal system. This is the only federal district in the United States that also is a federal circuit. So persons who are summoned for jury duty arrive at the court, and they come from within the boundaries of the District of Columbia. They cannot come from nearby Maryland. They cannot come from nearby Virginia. They have to be established residents of the District of Columbia. The pool is very small as compared to statewide pools and options that other states may have. And consequently, jurors, because of the demands, are summoned for jury duty repeatedly. And some persons who may be summoned for jury duty in the District of Columbia Superior Court will, within a short period of time, if the rule of thumb is not applied, be summoned for jury duty in the U.S. District Court. The problem arose that for a long period of time, it appeared that the pool from which individuals were selected for purposes of jury duty was not a true representation of the community. And as I began to say earlier, a jury of your peers doesn't mean that if you're an American-born Swede, that you're entitled to have 12 American-born Swedes on the jury. It doesn't mean that. The way the Supreme Court has discussed it and the way we understand it is that a jury of your peers means that it has to be a representative group from the community at large that is responsible to respond to the court. And for the longest time, it appeared that certain segments of the community were not being invited to serve as jurors. The sources of the lists were examined and scrubbed, voter registration rolls, tax rolls, and other Bureau Motor Vehicle rolls, and so forth. It seemed that there was consistently either duplications in the way people were summoned to come to court, or that there were significant gaps in how the system was working to get a full and representative sampling each time it summoned a pool to court. Now, in the Superior Court across the street, there is a system that jurors tend to approve of a bit more than perhaps over here at the U.S. District Court, in that it promises an individual who is summoned and who responds that that person's duty will last for one day or one trial. Of course, a trial can be many days, but a person believes that if he or she comes to court on a particular day and is not selected, then that's it until the next time they're summoned. While in this court, for example, the practice was for a while, although it has changed significantly, that the jurors were called in for significant periods of time, sometimes 2 weeks, sometimes 3 weeks, and the complaint was that jurors would come to the court and sit and wait and never even be summoned into the courtroom, creating disgruntled jurors, prospective jurors for the trials. That has been changed. Now jurors can be summoned and they can be put on telephone alert so that they call in every day at a particular time, and they're told at the beginning of the day whether or not they're required to report to court that day. However, this court system is, I believe, an exception. Not all court systems work alike. And as a result of the two systems working side by side, the one across the street in the DC Superior Court and the one here, there is still a lot of overuse or underutilization of jurors as they are summoned to come to court. So what does it mean to most of us, let's say to the judge, that you have jurors who are reluctant or just plain resistant to come to court and to spend that time in the very worthy endeavor of jury service? Fact of the matter is that although many jurors have trepidations about coming to court and responding to summonses, my experience is that once that juror is selected for a case, that the juror actually gets into the process, begins to enjoy the process, begins to identify with the process, and the competence and the quality of their involvement rises. And again, as I said at the outset, my experience is that jurors do an extraordinarily good job in rendering justice. So, what has happened in the meantime in situations where jurors refuse to come to court? In this court, I know that there have been instances in the past, I think this statistic has improved, that 40% or more than 40% of jurors who get summonses do not respond, do not come to court, do not check in, do not call in. They simply ignore the summons. And this is not a new problem. This problem was rampant, for example, in New York during the post-colonial period. And what judges had to do in those instances was to fine people and sometimes send out the authorities to arrest them, to bring them in, and to demonstrate the seriousness of the summons and the necessity for them to be there. Indeed, in the last several years, this court and the court across the street, the Superior Court, have taken additional measures to impress the general public with the necessity of showing up once summoned. I know when Judge Rufus King was the judge across the street monitoring this matter as the chief judge of that court, that he would hold special sessions where persons who had not come to court would be called in to face the chief judge and would have a discussion, and the prospect of incarceration was discussed as opposed to simply volunteering for another date to replace the date that this juror missed. In this court, because of the improvements that I earlier mentioned and other improvements, the situation has gotten much better, and jurors are beginning to respond more faithfully to their summoned appearance. Now, one of the points that that was made to me as appropriate for inclusion in today's discussion was the point about how jurors how they actually work, how they take on their responsibilities, and how the system prevents lawyers from excluding certain people from service on the court, on the jury. Jurors, as we know, and some of you may not be as familiar with the way the legal process works here, jurors are given a preliminary exposure to the case. The whole pool of jurors come in, and they're told generally what the case is about. Then the judge will ask them questions, or in some courtrooms, the judge permits the lawyers to ask the questions. But in any event, using the former model, the judge asks the questions, there's a questionnaire, they check off the boxes or the space responsive to that question, and then one at a time they are invited up to the bench with the lawyers present, at which time the judge reviews the roster of questions and then asks for the response to the questions that they have affirmatively recognized. At that same time, once those questions are canvassed, the lawyers are then given an opportunity to have some FaceTime with the jurors themselves, so that the lawyers can do follow-up on some of the questions that have been answered, or, for that matter, some of the questions that have not been answered. Judge Mize, who's sitting in the front row here, did an experiment some years ago where he proved unequivocally that it is a mistake not to summon every single juror who may be called upon to sit in that jury to the bench. The reason being that sometimes a juror may not answer any questions, and there are a variety of reasons why that happens. One of the reasons may be that the person doesn't hear well, or one of the reasons may be that the person just doesn't want to speak up honestly about matters that he or she may consider too personal. Or one of the reasons may be that they're so anxious to get that minimum fee for jury service that they want to do nothing to disqualify the possibility of them serving in the case. Or there are any number of reasons why a juror would not speak up, even though an honest response to the array of questions would elicit a response. And Judge Mize raised this point and examined the point and determined that indeed there was a significantly high percentage of jurors who had not responded, who indeed should have responded. For example, they were the victim of, accused of, or the witness to a crime. But for one reason or the other, they just did not want to address that point or answer questions about it. So So that process goes on, and then the lawyers will have an opportunity as one juror retires and before the next juror approaches the bench to tell the judge that he or she wants that last juror who was just interviewed at the bench disqualified, what they call stricken for cause. A strike for cause means that this person has demonstrated by answering the question, by the content of the answer, or by attitude, that this individual cannot be fair in judging the case. Those individuals will, if that argument is persuasive, the judge will eliminate that person without prejudicing that attorney's right to make other strikes, which are called peremptory strikes, which, as a rule, just allow the lawyer to strike a person with no explanation. However, as we know, in the 1980s, I believe it was 1986, the Supreme Court confronted a case called Patterson versus Kentucky. And in that case, there was an issue of why there were two or more African Americans stricken as a result of something that was never explained, the conspicuous fact being that the defendant was African American and these prospective jurors were African American. The jury turned out to be all white, and the case was appealed after conviction, bringing to the attention of the circuit and then later on to the Supreme Court that this was a process that was inherently unfair. In a criminal proceeding, the Supreme Court said, well, because this is a criminal proceeding, because there are such powerful constitutional rights that protect the individual charged in ways that would suggest that arbitrarily or for inappropriate reasons, jurors should not be stricken, and that the defendant therefore has been deprived of that right. The law was changed, and the Supreme Court referenced directly the fact that jurors could not be stricken because of their race. Some years later, maybe 2 or 3 years later, there was a case called Stevenson, in which the same issue arose. And in that case, it was a civil case, not a criminal case. And more or less the same thing happened. 2 individuals were stricken, and the defense attorney, the plaintiff's attorney believed that it was a racially biased process. The striking of these jurors were racially motivated. He lost the case. He lost the case until it went up to the Supreme Court. And then the Supreme Court had to answer the question, well, in a case that involves not the criminal law, but a civil case, can these constitutional precepts, can these constitutional principles be invoked? And the short and the long of it is that Supreme Court said, yes, these constitutional principles can be invoked because the 14th Amendment applies the Bill of Rights to individuals, and that because this case, no matter what, if you're in a courthouse, this is not exactly how they said it, but if you're in a courthouse and the integrity of the proceedings are in the hands of a judge, whether it's a civil case or a criminal case, then this case is happening, this process that is supposed to be protected by the Constitution and the integrity of the court is a case which is prompted by government, is overseen by the government, and consequently, it's not the individual persons, the corporation or the individuals involved whose rights are being damaged, but it's the rights of the people in the community to be selected for the jury. And as a result, that case kind of added to the whole concept of it being necessary for jurors to be fairly processed. You might say, well, what happens if a juror gets stricken and there's a challenge and the person who did the striking, let's assume it's a criminal case, it's the prosecutor, says, well, no, I didn't strike that individual because of their race, even though the defendant is of the same race, and there might be some assumption that similarity would bias the jurors' deliberations, but the person was not well educated enough. And this case involves documents and contracts and other business-oriented transactions that a person who's not well educated enough will not be able to understand, absorb, and act upon. Well, this is what happens in these cases when it comes up, and then the judge has to decide whether or not the individual proffering these non-discriminatory reasons is telling the truth or is not. And it's a tough situation for everyone, because if the judge indeed says, well, I don't believe you, I'm putting that juror back into the pool, it could be very difficult for that attorney to function in light of the fact that the judge has just called that individual a liar. So there are many intrinsic problems that arise in the nitty-gritty process of just getting jurors in the box. And then there are problems that arise when the judge, and of course the parties, try their very best to educate the jury to the matters of the case. For years and years and years, many judges, and I believe this is still the case with some judges, would not permit jurors to take notes in cases. This was, I think, because some judges felt that jurors who took notes would rule the deliberations, because if they had notes and other people did not, their opinion or their recollection or their references would override those of other jurors who did not take notes. Of course, I think that apprehension has been swept away by the reality of the situation, being that, in my experience, jurors are very responsible and do their very best to make up their own minds about matters. And of course, the jurors are told that they should consult with one another during the trial, and they're given during the deliberations, and they're given very specific instructions about relying on their own memory, not the memory of the lawyers, not the memory of the judge, or even the memory of other jurors if that recollection conflicts in a significant way with their own recollection. Then there was this issue, and still is this issue, of, well, how do you get the jury invested in the case? How do you get them to be something other than passive observers with an active role reserved only for them at the very end of the case when they're in the jury room? How do you get them to be activated in a way so that they have the incentive to really pay attention to all that's going on and to feel satisfied that they, in fact, understand what the case is about? Well, the practice, and again, Judge Mize was one of the individuals who led the movement to employ this practice, a practice that I've had for almost 19 years, and that is to permit jurors to ask questions. Now, there was a big upheaval about this when the committee that came up with these ideas and suggestions first broached the subject, because, of course, lawyers and judges always imagine the worst nightmare scenario when they think about whether something will work or not work. And of course, many individuals, especially in the criminal defense bar, felt that if, for example, the government failed to address a particular element of the crime, and then a juror happened to ask a question about that, and that prompted the prosecutor, for example, to then supplement the evidence so that that element could be met. Well, in my experience, that never happens. If there is some flaw in the presentation of the case by the government, it's not because they haven't addressed the elements of the case. It's because there's been something else going on. And in fact, this something else happens to both sides, in that sometimes lawyers use language which the jurors don't understand, but of course the lawyers have been living with this case for months, maybe years, and so their mind trips along quickly as questions are being asked and objections are being lodged. forgetting, of course, that these jurors are absolute novices to what this case is about. And so you have situations when jurors will write a question, and these procedures are very carefully circumscribed. They are never permitted to speak up in court, ask a question. They have to write it down. At the end of redirect examination, the judge collects the questions, shares the content of the questions with the lawyers, and the lawyers frequently, when they react, and they don't always react, but when they react, it's usually, oh my God, because they have forgotten something and that is important to their presentation of the case. Never an element of the crime, but something else that, for an acronym, for example, that's been used over and over and over again in this Title VII case or in this criminal case, and everybody's using it except the jury doesn't understand what this acronym means, or a failure to explain a particular process in a business negotiation, which is second nature perhaps to the judge, but far from second nature to the jury. So permitting jurors to ask questions is another one of the several approaches that judges have taken over the course of time to get jurors animated, to get them involved, to get them invested, to get them sincerely interested in deliberating and arriving at an outcome that is justified by the evidence. I'll just speak about two more things quickly, and I'll be done. There's many more things, of course, I would like to be able to speak to you about, but there are other important matters and events here to follow. So I'll speak about this issue of jury nullification. First of all, for those of you who are not familiar with our jury system, and for many of you who are familiar with our jury system through television, let me simply say that there is a popular misconception that lawyers can stand up in front of a jury and bamboozle them, can trick them, can get this jury thinking in the wrong direction, that the guile and the eloquency of the lawyer can easily mislead the jury, for example, in O.J. Simpson or more recent examples, perhaps. And therefore, the outcome is not really, the juries don't really work as well as people suggest, because here are examples of where obviously the jury has not been able to reach a conclusion that is based upon the evidence. Well, let me tell you that that conclusion, that assumption is wrong. In my experience, when a jury reaches a verdict that the media has not predicted, then many of us who rely on the media to tell us what's going on from day to day, and I'm not knocking the media, my son is a distinguished writer for the New York Times, that which the media has failed to incorporate gives many people the impression that the jury just didn't know what they were doing. Of course, what is a jury doing, for example, in a criminal trial? The only task, if you really want to boil it down to its basic component, the only thing that a jury does in a criminal case is to determine whether or not the government has proved each and every element of the crime beyond a reasonable doubt. As I tell my jurors, the defense needs to prove nothing. The defense needs to provide no evidence. The defendant does not need to testify, and his decision not to testify cannot be used against him, and so forth and so forth. So just let me say that there were times, however, when juries appeared to be ignoring the facts and reaching conclusions based on something other than the facts in the case. This is not a new phenomenon. In fact, in some states, I believe parts of Maryland, the jury is told during preliminary instructions that they have the right to reach a verdict that is not in keeping with the evidence in the case. Now, why would such a phenomenon take place? Well, for a very long time, in the District of Columbia, there was the perception that the police were slanting their arrests, and the prosecution were slanting their indictments and accusations at a particular group, young African Americans, and that because the penalties for these offenses, gun offenses, drug offenses, were so severe that many people in the community began to get disenchanted with the way the system was working. So people in Washington, D.C., for example, are pretty well informed. They read the newspaper. This is the capital of the United States. They listen to news shows, and they understood, in those days at least, what the requirements, general requirements of the sentencing guidelines were. And when they looked at a young African American, there was no evidence that this individual had been arrested or convicted before, and now he's facing the possibility of 20 or 30 years because of distribution of crack cocaine and with a gun. The jury began to feel that enough is enough. And no one ever told me this. This is my own deduction from what I saw and experienced, because I did see and experience verdicts come in that were not an acquittal in the truest sense, but represented a refusal to continue convicting this certain class of individual. So that was called jury nullification. Now, is jury nullification a good thing? Well, there's been a lot written about that. And when I speak to my students about that, about this topic, I tell them just consider the following. A man is accused of rape in the South in the 60s or early 70s. He's African American. The victim is white. However, there is significant evidence that he could not have committed the crime, even though he did act in a way that was, in the view of the majority of the community, inappropriate by saying or doing some things that were offensive to some members of the community. But in fact, the evidence clearly created more than a reasonable doubt, but was convicted anyway. That's called jury nullification. So I suggest that we not be locked into a term without thinking through what the term means and what impact it has in different scenarios. The last thing I'll talk about is an issue that has come up often in the United States and from time to time here in this area, Washington, D.C., Maryland, Virginia, and that is the problems that are intrinsic to the trial of a foreign-born individual. Let me use Latino as an example, where this individual is foreign-born, does not speak much English, and the witnesses that this individual intends to call are also foreign-born, their friends, their family, and they don't speak much English. And as a result of this, of course, there is the requirement that there be an interpreter to provide interpreting for everyone involved, for the jury, for the individual, and so forth. This may seem to some people as kind of a very fundamental precept of equal protection and due process, but let me tell you a story. When I was on the Superior Court back in the early 80s, and Hispanics, for example, were brought before the court for arraignment, it was unusual for that non-English speaking Hispanic to have a Hispanic lawyer, and it was almost unheard of to have an interpreter. As a consequence, when they were brought in for these quick arraignments on Saturday morning, sometimes from people arrested on Friday night, and if the moon was full, there were a lot of those, and they were brought in for quick arraignments on Saturday morning when the judges actually sat in that court. If an individual was brought up, and if there was somebody who said they could speak Spanish, someone who wanted to be appointed to the case, that person would probably be appointed. Rarely did the person actually speak Spanish, but they wanted the appointment. Every once in a while, they'd come before me, and since I speak Spanish, they'd get caught mouthing some gibberish, which was not Spanish. But Just as egregious was the fact that if this individual, for example, was characterized as having an alias, the automatic knee-jerk reaction of the judges and the prosecutor was that, well, people with aliases are obviously trying to avoid using their real name, and why do people not want to use their real name? Because they're hiding something, they're involved in criminal behavior, and they're trying to cloak their real identity. That person will be held pending further court proceedings. Of course, Latinos, especially those who are foreign-born, have two last names. They take their mother's last name and their father's last name. And some of them retain that even though they're here in this country. Many of them retain it until perhaps they become citizens and so forth. So it's really not a badge of dishonor to have two last names in the Latino community. Or, for example, situations that involve some Asians who we would learn later, are told that you don't look in the eyes of the person who is in power when they're asking you questions, because that connotes a certain ego or a certain inappropriate response to authority. So sometimes these individuals we brought up and they'd have their head down and they would not answer the questions by picking their head up and looking directly at the court or the prosecutor. And not infrequently, that was considered to be a sign of this person being shifty and unwilling to give truthful information. So what happens in these criminal cases, there has to be interpretive services provided on all levels, not only at the proceeding, but when the interview of the defendant or accused takes place. Also needs to be provided when the indictment is being explained, when witnesses need to be interviewed, and so forth. And then, of course, that interpreting service needs to take place in the courtroom so that the judge, the jury, and everyone else involved will have a clear understanding of what is going on. Now, the edge of that problem touches upon what happens when there are jurors who speak Spanish. And whose Spanish do they believe or do they credit when things are said that the interpreter says one way, but the juror understands another way? What procedures accompany that inconsistency? And judges have had to figure out procedures to make sure that the procedures are not disruptive. Sometimes the interpreters are wrong because their Spanish stems from a different Latino culture and the words have different meanings and so forth. So those are just kind of the very tip of many issues that I wish I could speak to you more about, but I think would probably more than cover my time permitted. I'm sorry if I've taken too long. Okay.
Well, that was really a very stimulating introduction to the panel discussion we will now hear. But I really did want to thank Judge Urbina again for being with us today and for really being so thoughtful and compelling in his remarks. So we do have a very impressive panel today. All of our panelists are experts in our justice system and regularly consider issues around jury participation. But before I turn the program over to our panelists, I have the pleasure of introducing this afternoon's moderator, Liliana Coronado. Ms. Coronado is a deputy federal public defender in the Central District of California. She joined the Federal Public Defender's Office in 2003, where she represents indigent individuals charged with federal crimes. In this capacity, Ms. Coronado has tried immigration, drug trafficking, firearms, and fraud cases. Currently, she is on detail to the House Judiciary Committee, where she handles the criminal justice portfolio. for Congressman John Conyers, the ranking member on the House Judiciary Committee, and Congressman Bobby Scott. So please join me in welcoming our moderator, Liliana Coronado, and our distinguished panelists.
Thank you, everybody, and welcome. And let me just say I'm a public defender, so I'm very not used to being up here. It's a whole different vantage point up here, but I'll enjoy it for the hour that I have. I think Judge Urbina did a wonderful job of talking about some of the fundamentals of our jury system. What I think the panel wants to do today, and I think what we want to do, is explore some of this in greater detail. The right to a jury trial is one of the most fundamental and important rights guaranteed by the U.S. Constitution. But it hinges on a compelled system of jury service, which calls upon ordinary people to put into action extraordinary ideals. Things like fairness, due process, deliberation, and debate. And of course, the presumption of innocence, just to name a few. It is because of the importance of the rights at play in the jury system that we care as a nation about juror engagement and participation. This afternoon, we plan on examining the important role that jurors play in carrying out so many of the Constitution's promises and explore ways to promote inclusion and representation in some of the ways that Judge Urbina talked about this afternoon. We'll look at what our jury system looks like today, what jury trials actually look like, and not necessarily how the media portrays them. And we'll ask whether our system is coming up short for jurors and maybe for litigants as well. We'll answer some of the questions about how we're doing in terms of racial bias 25 years after Batson versus Kentucky. And we'll answer the question if there still is there still racial bias in jury selection? Beyond jury selection, like Judge Urbina was talking about, how do we get jurors excited about jury service in the first place? And finally, we'll look at what judges and lawyers can do once people are in the courtroom to ensure that trials are both fair to the parties and enjoyable for juries. We have 4 outstanding panelists that I'm about to introduce. Each bring their unique experience and perspective to the discussion. So we'll start the conversation with them, but then we're going to be hoping to get some questions from you all, from the audience, at some point. So let me introduce first Judge Gregory E. Mize to my right. He is a senior judge on the D.C. Superior Court, and he's also a judicial fellow at the Center for Jury Studies, which is part of the National Center for State Courts. In addition, he's an adjunct professor at Georgetown Law School, and he has written extensively on the subject of jury service and jury service innovations. To my far left is Alicia Addario. She is a senior attorney at the Equal Justice Initiative in Montgomery, Alabama, where she works on issues of juror exclusion and inclusion and bias. Also to my left is Professor Andrew Ferguson, who's an assistant professor at David A. Clarke School of Law at the University of the District of Columbia. He brings experience both as a litigator and a thinker and writer about the constitutional underpinnings of jury service. And last but not least is Mr. Scott Patterson, to my far right, who is the state's attorney for Talbot County in Maryland. He will bring the perspective of a prosecutor working in the trenches to this conversation. So let me start by asking Professor Ferguson a question. Judge Urbina gave us some historical context, but I'm wondering if you can talk a little bit about why this right to a trial by jury is among the Bill of Rights' most important guarantees. Why do you think our founding fathers decided to make juries an integral part of the justice system? And why was it a compelled service, so much so that sometimes the resources of the Marshal Service or the Sheriff's Department are utilized to arrest people and bring them in to do this duty?
I'd be happy to, and I thank ACS for this wonderful opportunity. I'd note, actually, the traditional history was, even in the time of the founding, when people skipped jury service, the equivalent of marshals would be sent out and they'd be fined in pounds of tobacco for failing to show up for their jury summons. So it's an ancient tradition, an unfortunate one. But I'd like to speak here today both as a former trial attorney, where I learned from and met lots of jurors and studied from them and with them, and also an academic who sort of looked at juries in America. And to understand the idea, which is sort of the fundamental part of this discussion of exclusion and engagement, you have to understand a little bit of American history. Symbolically and literally, the jury was part of America before there ever was an America. The right to a jury trial came on those same boats to the Jamestown colony in 1607. And in the Jamestown Charter, there was a right to a jury. In each of the 13 colonies, independently, there was a right to a jury trial. In fact, the British attempt to strip American juries of the ability to try criminal and maritime cases was one of the reasons why there was the War of Independence. Thomas Jefferson, in the Declaration of Independence, wrote about the deprivation of jury trials. It's right there in the Declaration of Independence, and it's there, as Judge Urbina said, in the Constitution, as we said in the introduction, in the Constitution. It is the only right not only written in the actual text of the Constitution, but in the Bill of Rights. If you look at the Sixth Amendment right to a jury trial for criminal cases, the Seventh Amendment right to a jury for civil cases, the Fifth Amendment right to a grand jury, you have 3 out of the first 10 amendments. Then if you understand that the First Amendment right against prior restraints and the Fourth Amendment right against unreasonable searches and seizures, which were effectuated by a jury trial, means that half the Bill of Rights, half of our fundamental Bill of Rights, was about the right to a trial, a right to a jury trial. And you say, why? It's not just history. It's about something more fundamental. It's about the fact that it connected a great American ideal of democracy, of liberty, and self-government. And this ideal of civic participation, the idea of ordinary citizens coming to decide things just like they came to vote for their legislatures, was fundamental to the founders. In each branch of government, there is this requirement of participation, this requirement of engagement. It was an insight that was recognized by the Federalists who were arguing for the federal Constitution, as well as the Anti-Federalists who didn't necessarily and were scared of a federal government. It was recognized by observers in the first generation, like Alexis de Tocqueville, who said that the jury trial, the jury experience, is a place, a public school, where ordinary citizens, like all of you, come to learn what it means to be an American, what it means to be a democratic citizen. And yet, as the other part of this discussion is that despite a push for engagement, despite a push for participation, the institution itself was starkly exclusionary. Exclusion of women in jury service was not formally ended until 1975, within my lifetime. Exclusion of African Americans was formally ended a century earlier, but in practice continued for decades afterwards, and I think, as we'll hear later, continues in other forms to this day. And it is no surprise that as society moved to democratize the jury, away from white, male, property-owning men to a larger inclusion of women and minorities, that the push for equality began with juries. But before and after the 19th Amendment, the push for women to be in jury service was part of the progress. The legal cases that the NAACP Legal Defense Fund brought that began in the South as a precursor to the Civil Rights Movement were focused on juries. The great civil rights pioneer, Charles Hamilton Houston, won his first case in the Supreme Court based on a jury exclusion case. And yet, as we heard, when people receive that summons in the mail, do they think about Thomas Jefferson? No. Do they think about the Constitution? No. They think, why me? Why now? I'm too busy. I have something else to do. And so I'd ask that as we sit and talk about this idea of jury engagement and inclusion, we talk about how we can engage jurors, ordinary citizens, into the principles of the Constitution, how we can get jurors to see that jury duty is Constitution duty, that it's not some historical mistake, it's not a way to bother and take them away from their ordinary lives, that this is part of their ordinary lives. This is part of what it means to be an American citizen today. And that all of those protections from voir dire to deliberations are there for a reason. And that the jury today provides that same civic space that it did throughout our history to practice the constitutional values. As we heard, the constitutional values of participation, deliberation, equality, fairness, and accountability are in this room. So if you guys were a jury right now, and you sat there and you listened to Judge Urbina give you the jury instructions and you paid attention, you'd see that the Constitution was alive all around you. And so I think as we think about ways to sort of build engagement, we have to think about ways to make those principles come alive, to the 32 million Americans who get summoned to juries every year, and the 1.5 million actual jurors who sit there, and not just alive when they come here, but then becomes alive when they're actually sitting there. And I think Judge Mize will talk about how to do that more.
Thank you, Professor Ferguson. I want to go to Ms. Addario next before we get into actually the discussion about building on some of the things that you said and some of the things that the Judge Urbina said about how to excite and engage jurors more. I want to talk about thinking about some of these issues with respect to the framers and how important they thought that the right to a jury trial was and is. How are we delivering on this promise that citizens are entitled to a fair and impartial jury? We know from history and from Professor Ferguson that there has been systematic exclusion of women and minorities from the jury, from jury service. The Supreme Court certainly has expounded a jurisprudence that says that we have a great respect for this right. How are we delivering on that promise? And if we are coming up short, what can we do to sort of improve on that particular aspect of jury inclusion?
Yeah, the Supreme Court has certainly talked a lot about the importance of inclusive and representative juries. And I believe that's because inclusive representative juries are very important to the legitimacy of our justice system. People are much more likely to see a decision by a court as legitimate if they see the body making that decision is representative of the community. And it's also true that studies have shown that when you have a diverse jury, they spend a longer time deliberating, they consider a wider range of facts, and they reach more accurate decisions. They make fewer errors. But unfortunately, what EJI has found when we've studied this is that there are still, even today, many places where juries are routinely selected that do not reflect the communities that they're drawn from. And I think what we're seeing there is the difficulty in implementing on the ground, in trial courts, the promise of the Constitution when judges, prosecutors, and other lawyers are not genuinely committed to those practices. So we still see jury pools that are not representative of a fair cross-section of the community. And we also see the use of peremptory strikes to exclude groups from jury service. And I'm going to talk mainly about racial discrimination in jury selection, especially in criminal cases, because that's what we deal with the most at EJI. And part of the reason we continue to see non-representative juries is that there has been very inconsistent enforcement of the prohibitions on racial discrimination in jury selection. The Civil Rights Act of 1875 actually prohibited racial discrimination in jury selection and imposed criminal penalties for that. But it has been over 135 years since that was passed, and it has never been enforced. No one has been prosecuted under that act. In 1986, the Supreme Court decided Batson v. Kentucky, which prohibited racial discrimination in peremptory strikes. But now, more than 25 years after Batson, we see that prosecutors are often able to easily evade its prohibitions by providing supposedly race-neutral reasons, like a juror's too young at 28, they're too old at 43, didn't like the way the juror walked, the juror lived in a high-crime area or a predominantly black area, or the juror worked at a historically black college. These are reasons that we have seen upheld as legitimate race-neutral reasons under Batson. But courts are just too frequently willing to look past those reasons, and discrimination just goes uncorrected. Even in cases where prosecutors have used all or almost all of their peremptory strikes to exclude African Americans from the jury. A couple examples. In Tennessee, in the 25 years since Batson, there has never been a case reversed under Batson. In Alabama, where I work, We have a case where in 2010, the prosecutor said that he struck a number of African Americans because they weren't sophisticated enough to understand the evidence in the case. And discrimination persists also because even where there are reversals, there are no consequences for the lawyers who've engaged in discrimination. And people who are the victims of this discrimination often don't even know why they weren't selected for jury service. So one thing that we've done at EJI is we often go out and speak with jurors who courts have found were illegally excluded under Batson, and they usually don't know that they were discriminated against. But when we tell them about the reasons that prosecutors gave for striking them from the juries, they're often very hurt. Some of these reasons are very insulting. And so there are real victims of this discrimination. And because we don't see consequences for the lawyers, we've actually filed at EJI a civil rights suit with plaintiffs who were excluded from jury service on the basis of race by the district attorney in Houston and Henry counties in Alabama. That district attorney has been reversed 7 times for violating Batson, but we continue to see discrimination in case after case where he is using peremptory strikes to exclude over 80% of the African Americans qualified for jury service. So while we've come a long way in making juries more inclusive, there's still a lot to be done to really live up to the promise of the Constitution in this regard.
Thank you, Mr. Addario. I want to turn next to Mr. Patterson. Listening to Mr. Addario, I couldn't help but wonder what about the role of a prosecutor in ensuring that juries are inclusive. They're often, even in the short conversation here with Ms. Addario, prosecutors are often blamed for exercising those unlawful peremptory strikes. And indeed, the report by EJA revealed that some prosecutors, tell me if I'm right, Mr. Addario, are even trained to exclude racial minorities. So are prosecutors just getting a bad rap? Are they just as invested as everybody else, as defenders and judges, in ensuring that juries are inclusive? Can you talk a little bit about that?
Thank you. I'd be happy to. Discriminating against jurors for any basis, be it race, sexual preference, religion, ethnicity, country of origin, for any reason is wrong. It's just flat out wrong. We know that it's wrong. The prosecutors are, I think, to use your term, given a bad rep, because when does this come up? It comes up after a conviction when the defendant appeals a conviction and raises a Batson challenge saying that he was discriminated against. If there's an acquittal, there's never a review. So the state can't appeal acquittals and say, well, you know, the defense attorney was striking jurors for improper reasons in violation of Batson or any other constitutional right that would be a violation to exclude that juror. So from the standpoint of using your term getting a bad rap, it's the prosecutors that are focused on because it only happens after there's a conviction. I believe that prosecutors want to have fair, just verdicts in cases. Keep in mind, first of all, let me go back to what I said originally. Striking a potential juror for an unconstitutional grounds, and we're focusing on race, so we'll say for racial reasons, is just flat out wrong. The concept that the attorneys in the case, the defendant's attorney and the prosecutor, are trying to seat 12 impartial people is a fallacy. They're not doing that. The trial is for lack of a better word, a contest of issues, guilt versus innocence. And each side, the prosecutor and the defense attorney, has their perspective on whether the individual is guilty of the crime with which he or she is charged or not. But in the jury selection process, assuming that you set aside the unlawful, unconstitutional reasons for striking a juror, each of those two attorneys is trying to find jurors that are going to be receptive to their point of view, that may have a bias towards their point of view, towards what they present in the evidence or the way they contest the evidence of the other side during the course of the trial. As a result of the selection process, with those two attorneys battling in jury selection, trying to find jurors that are going to be receptive to their point of view, whether they've got a leaning towards them or not, in the process, since both sides get to challenge jurors and select jurors, then at the end you end up with, hopefully, a balanced jury that even though they may have a bias one way or the other, when the evidence is presented, they will then evaluate the evidence and decide the case based on the evidence and the evidence alone. One of the things Judge Urbina mentioned in his talk that I caught my attention is I don't know of any time any court has instructed a jury that they can render a verdict notwithstanding the evidence. Every instruction that I've ever heard to a jury is you must base your decision on the evidence and how you view it and how you weigh it, but you can't ignore it. So yes, concerning the issue of whether or not prosecutors are unfairly singled out, I would say I believe that they are, because the only way you hear about it is after there's been a conviction, because you don't hear about. I don't know if my counterpart at the end of the panel would acknowledge that a defense attorney can also commit a Batson violation or not. I don't know if she'd acknowledge that, but if one assumes that defense attorneys can do that, you're never going to hear about it if there's an acquittal, because there's no way to contest it.
Thank you, Mr. Patterson. Maybe at some point Ms. Addario can respond to that, but I wanted to go to Judge Mize to talk a little bit about sort of in the courtroom, on the ground, what is happening in terms of changes and reforms to the jury system. There seems to be, I would say, I think in the last 20 years or so, some efforts to really reform our jury system and our jury system of jury service. Judge Urbina got into some of those earlier today, but can you tell us what is happening sort of on the ground in the legal profession to improve trial by jury? And we've heard about some of the shortcomings, some of them larger than others. Can you share with us some of the reforms that are being implemented around the country?
I'd be happy to, and I also want to lend my voice of thanks to ACS for hosting this forum about what is really a jewel of democracy. Even though it's been around and has such a great constitutional pedigree, as Professor Ferguson told us, the trial by jury kind of was in sleep mode, being done the same way for centuries, from colonial days to almost modern times, as judges and lawyers controlled trial by jury and managed the rules of evidence and the trial procedures by methods that they learned from another judge, a senior lawyer, and the system kind of just kept doing the same things over and over again. But I think I point to, we are in a jury innovation, jury rejuvenation movement in the last 15 or 20 years that I hope continues, and I think a program like this is part of it. But I point to the Batson decision, which not only dealt with peremptory strikes and policing of those, but the court did something in Batson that I think started the revolution. And what the High Court said was that in a trial, the litigants have their rights. The justice system has an interest in making sure things are done properly, but potential jurors have rights, that citizens have the right to serve, and a court has the duty to make sure that a citizen's right to serve on a jury is not abridged merely because of his or her race or gender. That is revolutionary because judges and lawyers have always been thinking of the parties. What is fair for these parties? And I'm going to, as a judge, umpire this according to the rules so that they have a fair adversarial event. With that new consideration on the horizon, something else happened in the 80s, and that was the crack cocaine epidemic. And it flooded our big cities, and criminal prosecutions took off. And here in the District of Columbia, which I know best, when I was appointed to the bench in 1990, the criminal caseload skyrocketed as more and more drug cases had to be tried. And then around the country, mandatory minimum sentences started to be enacted by legislatures to get tough on crime. And many defendants said, I've got nothing to lose, I'm going to trial. And so we had an increase in trial by jury in the criminal mode, in the criminal sector. And then on the civil side, corporate America took a hot coffee spill on a woman's lap and made it the poster child for juries can't do it right. It's a crapshoot, and jury trials have got to be, some would say, eliminated. The juries are not competent to handle civil litigation in many ways. So it's this as a background. In 1990, I think it started in Arizona with a very insightful, visionary judge, Mike Dan, who was the chief judge of the Arizona, the Maricopa County Superior Court in Phoenix. He had a sabbatical. He gave up his chief judgeship. He went to the University of Virginia. He wrote a master's paper charting the history of trial by jury in the Anglo-American system. And he charted how juries really in medieval England were like grand juries. They were investigative, they were very active. And by the course of time, modern juries are this passive group that just sit there and wait till the judge and the lawyers give them something to do, give them permission to do things. A passive jury was the modern jury. And to bring a longer story short, Mike came back. His article was read by the Chief Justice of the Arizona Supreme Court. Chief Justice Feldman said, Mike, you've got something here. We're gonna see if we can make trial by jury better here in Arizona. And after creating a commission that was chaired by Judge Dan, recommendations came forward in the title, The Power of 12. And in that Power of 12 document, jurors were given a Bill of Rights, a juror Bill of Rights in Arizona, the ability to take notes during trial, the ability to ask written questions of witnesses, the right to have a meaningful response from a judge when they say they are stuck during deliberations. And so the Arizona Supreme Court in 6 months adopted new rules of criminal procedure and new rules of civil procedure, empowering juries to be able to do things, to help get tools to do their job better. Lo and behold, within 4 years, 10 states, including here in the District of Columbia, created commissions to study their jury system. And we didn't even know about the Arizona effort at the time we started here in DC. By the year 2000, 38 states had created commissions to study how they do jury trials, learning what's happening in Arizona, in some degree learning what's happening in DC, and we have an innovation spirit about us. Then comes a National Jury Summit. The Chief Judge of New York hosted in New York in 2001, and 400 commissioners, lawyers, judges from around the country start learning what states are doing. And then an enlightened president of the ABA, Robert's last name escapes me right now, big national law firm in Richmond. He makes as his mission for his presidential year, we're going to show corporate America, we're going to show the citizens in America, and we're going to show lawyers that we believe in trial by jury, and I want, by the close of my presidential year, I want some gold standards that we can give to judges, give to lawyers, as this is how we want jury trials to be managed and conducted in the United States. And in 1 year, the House of Delegates adopts principles for juries and jury trials, relying on empirical research about how people make group decisions, how people retain information. And as the social sciences have told us that this old model of how to conduct jury trials, juries should stay silent, they should be passive throughout the process, is really bunk. And that's not how we learn. And that's not how we teach in higher institutions and in grammar schools. Let's bring the empirical sciences, psychology, and education principles to trial by jury. And now we have, here we stand in the 21st century with enlightened judges, brave lawyers, urging judges to do things in the courtroom, allow things in the courtroom that will give the jurors a better ability to find out what the truth is, what the facts are, and at the end render a truly fair and impartial verdict. It's a very exciting time to be concerned about trial by jury.
Thank you, Judge. I want to turn next back to Professor Ferguson to talk, sort of piggyback a little bit on what Judge Mize has indicated is happening around the country in terms of reform. You have done some writing and some thinking about trying to engage and excite jurors and try to sort of, I think you call it sort of a shift in consciousness from sort of a tedious, jury service as a tedious obligation to, to understand the constitutional underpinnings of service. So I wanted to see if you could talk a little bit about how do we accomplish that? How do we go from this idea that when people get their jury summons, as someone indicated earlier, they groan to this, to getting to teaching jurors or teaching folks before they get into the courtroom that this is an important civic duty that really has a great deal of importance in our community.
I think there are three answers to that I have. I probably don't have time to go through all of it. But the first, I think, involves education. It involves seeing the connections, the constitutional connections of a jury to your citizenship. If you think about the millions and billions of dollars spent trying to get people to vote, and then think about how many dollars are spent trying to convince people that jury duty is a good thing. Back in the time of the founding, some founding fathers said jury duty was more important than the right to vote. It was that fundamental to the world. My sense is that there are several things that can be done to engage jurors. The first is to make jury duty more patriotic, to make people see this is actually a time of the world in America where people seem to care and read the Constitution. People from all stripes are now reading the Constitution. If they read it carefully, they'll see that jury duty is part and center to the structure. But then when they come into that day, right, they get the summons, they groan, they then think about what it means, and maybe they sort of get a little spirit of patriotism when they come there. They need to be instructed in the courtroom. And, I personally think, I know it's somewhat contested, that you can use jury instructions, you can use jury instructional videos to take this moment. If you consider jury duty as a day, the one day you have to be an active citizen, maybe there'll be others, but at least on jury duty, you have to be an active democratic citizen. And since you're probably going to be sitting in that jury room for a long time, maybe you should take this moment to consider why people died and fought for this right, what it means beyond you, why the Supreme Court has said it's your right, and that you could use jury instructions to educate jurors about the Constitution and the constitutional principles behind. You could create a parallel movement of like the get out the vote idea, but for jurors, right? You could have seminars and courtrooms and projects like this to get people engaged to see those constitutional principles, not to change the way the juries work now, but to change the way jurors think about jury duty. I think that as a small step is one way to do it, and I think educational programs like this are a great first step. And the second step is to talk. I mean, if you think about the people in this audience, at some point in your life, you're going to get that jury summons. In D.C., it could be tomorrow, for all you know, and then it'll be 2 years after that, like clockwork. But when you get it, to recognize that it shifts your paradigm. This is your one day to be a constitutional citizen, and that means something, and you should be proud of it, and you should want to embrace it. And then, fortunately, thanks to people like Judge Mize, when you get into the courtroom, you are now being asked to be an active participant. You're not just a passive log there listening. You have to think and engage and think and decide and practice those skills of democracy. Participation, deliberation, understanding fairness, equality, accountability. They're all there, and you just have to see it.
Ms. Addario, if we do the things that Professor Ferguson is talking about and sort of engage people and change sort of the consciousness about what jury service means, and then in the courtroom we make some of the changes that Judge Mize talked about and that are reflected in the ABA principles about juries and jury trials, from a civil rights perspective, do you believe that these reforms will create a fair system? And while we're on the topic, how do we actually measure fairness in our system from your perspective? Can you tell us that in all of 5 minutes?
Those are some tough questions. I think that those reforms would be great. I certainly think that to get more representative juries, we want to be having those conversations, in communities of color. That's certainly something that EJI has worked on, reaching out to organizations in communities, NAACP, other local African American groups, to talk about the importance of jury service, because I think that, African Americans are no different from anyone else. They get the jury summons and they think, oh, I don't know if I want to come in. But when you talk to folks about the importance of this right, about the way that it does make a difference for people having fair trials, I think a lot of people in those communities are conscious of what's happening in the criminal justice system in maybe a different way. They may know more people who are affected by the criminal justice system. Certainly that's not true for everybody, but I think like the NAACP is often engaged in criminal cases as well. And so they see the way that there is unfairness in the criminal justice system on the basis of race, but they don't always connect it back to juries. And so I think those are very important conversations to have, and then that those organizations can, hold their elected district attorneys accountable for, are they allowing African Americans to serve on juries? I mean, we are hoping to encourage groups like that to go in and have a meeting with their district attorney and ask them, how many African Americans are you striking from jury service? I'd like to see some numbers, some data. And because those are elected officials, at least in Alabama and I think in many states, hold those officials accountable for the discrimination. And I'll just quickly respond to your question earlier. Definitely no attorney should engage in racial discrimination in jury selection. But I do think it's important to put that in a historical context. The exclusion of groups from jury service has not been equally applied to all races historically in this country, and I think that's a very important thing to keep in mind. I'm not even going to try to address how we know if our justice system is fair. That is far more, I think, than we can get into today, so I'm sorry.
Understood, no problem. Mr. Patterson, all of this sounds good in theory, but you're on the ground. How do you see all these reforms in this movement playing out in practice? Specifically, one of the things that Judge Mize talked about was the Juror Bill of Rights and the rights that jurors have to serve. And certainly, I think what EJI, in terms of the report and the civil suit that I don't know if you've had a chance to talk about, but I'd like to talk about at some point, sort of go towards in that direction. But as you said earlier, when you're in the courtroom and you're talking about parties who are all seeking jurors, and I know because I've been there, all seeking jurors who are going to see the case from their perspective, how do we balance this idea that jurors have these rights themselves against the criminal defendant's right to a fair trial and also a prosecutor's right to present the evidence as they would like to?
Before Judge Urbina spoke, the panel today, the conversation was introduced by our ultimate moderator, who made a statement at the very beginning, which I wrote down, which I found remarkable because it was very broad-brushed and one that I don't agree with altogether, but she said, "Citizens despise jury duty." I believe a direct quote of what you said. And some do, some don't. The ones that do probably do for lots of different reasons, as many reasons as there are people. They might be frightened, they may not understand, they may be intimidated. Some may come in as a sole proprietor of a business, and they see that their business is going to be shut down for the period of time they're on jury duty, and they despise the idea that they can't operate their business, they're going to lose business, or they're going to lose the opportunity to support their families. Some have perhaps health issues, some perhaps have family issues. Lots of people have lots of reasons why they don't want to participate. Other jurors come in, and they are more than happy to be on juries and exercise that constitutional right to be a juror in a case, and they look forward to it. So we really have two issues here. One is the big issue: how do we get the whole populace to embrace the idea that not only is it an obligation to be on a jury, but it's a right and one you should be happy about? I don't know that any of us have that answer, or that we'll ever be able to do that, to take the country as a whole and get everybody to willingly come into a courthouse to serve on a juror. Then there's the other issue of, once we have a jury there, how do we engage them and make them a productive jury, which is a wholly different situation altogether. So we're talking about two different things. On the latter part, and I guess this directs towards Judge Mize's comments directly. Let me digress for a moment. I have, you can tell I'm kind of old, and I've been doing this a long time, but I've been a defense attorney, I've been a prosecutor, I've been practicing law for 40 some odd years, from both sides of the trial tables. In my jurisdiction, a number of years ago, all the juror pool, the big pool, was taken from the voter rolls. Then it changed, and it included the qualified jurors were taken from the motor vehicle records. If you had a driver's license in the state, then you were eligible. You were eligible, at least initially, to be brought in, and then there might be other disqualifiers that would disqualify you, but it enlarged the pool greatly. We found across the state that it made a huge difference. We found out that there were a number of people who were not registering to vote because they didn't want to be on juries. That was a bad thing. To give up one constitutional right to avoid another constitutional right and or obligation, depending on how you look at it, it was a bad thing. So by enlarging the pool and going to motor vehicle records as opposed to voter records, that was a good thing from the standpoint of now people might go in and register to vote because they don't have any reason not to avoid jury duty. But it also broadened the base of people that came from a lot of different economic backgrounds that really, when they are brought into a courthouse and told that they're being looked at to be on a jury, once again gets to the economic hardship that I posed. But they're there, and oftentimes they were selected and put on juries. We oftentimes will debrief juries after trials to figure out what they heard, what they listened to, what they liked, what they didn't like, what sorts of evidence they listened to that they based their verdict on, no matter which way the verdict went. We do it both ways. I don't just do it as a prosecutor if there's an acquittal or as a defense attorney if there's a conviction. We do it both ways to figure out what juries and jurors need in order to be able to make the experience meaningful. And we are finding recently that there are, in more cases than not, a number of jurors, it might be one, it might be two, it might be four, that all they want to do is get out of there. It's messed up their day, it's hurting them for whatever reasons, and they don't care, they don't want to be there, they just want out, cast the vote, do what you're going to do, let's get on with our lives. And that is horrible, that is not good. Now, the problem is, how do you weed those people that just don't care, that don't want to be there because they've got too many other things going on out in the first place? And it's got nothing to do with race, it's got nothing to do with ethnicity, it doesn't have anything to do with gender, it doesn't have anything to do with sexual preferences, it just has to do with they don't want to be there. And then once they're there, how are you going to engage them? And that is the second part of this problem, how to engage them. Now, I read through the ABA work that Judge Mize has talked about. And when you read through it, it is solid work. The principles in here are solid principles. I don't think that you take each of the principles and however many there are all together. 19. I was going to say 15, but thank you. I don't think that you can take exception with any of them. They are all right on. However, within there are some things that are being espoused here today that I would take exception with. And number one is the active participation of the jury in the trial. Both Judge Urbina has mentioned it, Judge Mize has mentioned it, and it has to do with the jury participating by asking their own questions. I'm here as I'm a prosecutor from Maryland, but I'm also a director on the board of directors of the National District Attorneys Association. As a matter of fact, I'm here at the request of the National District Attorneys Association because the original person who was supposed to come couldn't, and I was close by, and I was an easy snag to get here. So, which is fine. I'm happy, and this has been a real experience for me and educational. I am more than happy to be participating in this panel. But when the framework was given to us, to the panel members, about what this panel is about and the questions were going to be asked and which we were going to go and some of the materials to review, I contacted the executive director of the NDAA and said, look, I can sit up here and be Patterson, the prosecutor from the county in Maryland where I live, and just speak my mind, or I can represent the NDAA view on some of these issues, but I need to know what the NDAA view is. And so they put out a quick survey last week across the country concerning this one issue about jury participation in the trial, and found that, yes, it does happen in some states in the union, and you probably know the number, but it's a minority of states. But of the ones that responded to say, yes, we do have that, no one responded saying, boy, this is a good idea. As late as this morning, I happened to be meeting with the Maryland Attorney General on some environmental issues. And one of the Maryland Attorney General's directors of environmental issues was a former prosecutor. And I mentioned that I was coming down here. We hadn't seen each other for a while. I mentioned it and what we were talking about. I said, well, what do you think about this issue? And she was a former woman prosecutor. I mean, she's still a woman, former prosecutor. She said that there came a time that in her jurisdiction that started happening. At the beginning of trial, as has been my experience, and in her court, the judge will say to the jury, if you have any issues, please send me a note and I'll deal with them. Meaning, I'm not feeling well, we need a bathroom break, can I contact my home to say I'm going to be late? Those types of procedural issues was what he meant. But he started getting some questions about the trial, questions about evidence, questions that they wanted to know answers to, and he started answering them. It kind of took both sides back, and the response was, once again, neither side, both the prosecutor I was talking with or the defense attorneys in the cases that he did that in, he's now a retired judge, so he doesn't do it anymore, liked it, that it just was not a good thing. So if you read through this book, of the 19 recommendations, you get to one principle, which I think is 13, and you get to a subparagraph, which is C, and you get to a comment on it, and I was just reading it, as you read it on page 96 of however many 100 some pages, it says, the practice of jury questioning, especially oral questioning, has often been frowned upon, particularly in criminal cases, due to concern that it risks compromising jury neutrality and encouraging premature deliberations and unduly delaying the proceedings. And so while what Judge Mize says that this work by the ABA and the principles on engaging juries as far as, yes, they should be allowed to take notes, which is, to me, I mean, that seems like a no-brainer, and it promotes giving them notebooks with various advisory instructions and giving them copies of the instructions at the end of the case when they go back in to deliberate are all good things to engage them, to make sure that they are aware of what they are doing and their responsibilities and how they exercise it so they're not operating in the dark blindly, are good things. But as a practicing trial attorney, and having been so for a fairly long time, the concept of engaging them by letting them participate in the trial, I find to be, in my opinion, and those of my colleagues across the country that we've talked to, not a good idea.
Thank you. I'm going to ask Judge Mize to give a very quick response to what Mr. Patterson has said in terms of reluctance perhaps of some parties who've been doing jury selection, jury service, and jury trials the same way for many years to engage in some of these reforms. Not that they have a choice when the judges are implementing them, but is it just that we trial lawyers are control freaks, or are there real concerns that need to be balanced in the courtroom?
We're human beings, all of us, and if we've been doing things a while, if you've been hitting a golf ball a certain way for 15 years, it's going to be very difficult to modify your swing unless you're, extraordinarily gifted in some ways. So I think whether you're talking about medicine, the law, teaching, therapy, nursing, et cetera, we develop habits. And you add to that in the legal profession, we develop jurisprudence, and we develop teachings and theories, and those things take hold. And then we have a guild system. As a young prosecutor, I want to learn from the veteran. As a young public defender, I want to learn from the veteran. As a new judge, I learn from a veteran. And this adds to the keep doing it the way you've been doing it. And what has really happened, and I think this is in other professions as well, we're starting to learn from other professions. And as I mentioned earlier, the social sciences are now being looked to, and empirical research, methodology of not saying, this will never work, or these are the arguments against doing this, and these are the arguments for. Well, a scientist, a careful person approaching changing policy, give me some facts. And what has happened is that Arizona didn't change and give jurors the right to ask questions. Indiana Supreme Court didn't change, giving jurors the right to ask questions. Florida didn't change, giving jurors the right to ask questions. Wyoming didn't change to create its rules giving jurors the right to ask questions without doing some homework. And ever since Judge Dan's careful work, the Legal Academy, Sherry Diamond at Northwestern, Valerie Hans at Cornell, and others have gotten permission from chief justices to do research, to interview jurors, to have cameras in deliberation rooms with the permission of the jurors, with the permission of the parties, with the permission of the lawyers, with the permission of the judge, and they study, do people violate the rules that the judge said, or do they keep them? What is really going on? The research is unbelievable. We know, to a T, what is the likely number of questions asked by a jury in a trial that will be permitted, because it's been studied several times carefully. 76% of the questions asked by jurors in national research where these things are allowed, the judge allows the question to be asked. In the remaining 24%, the jurors are asking questions for legal conclusions, or they're asking questions that this witness cannot speak to. Quick, judge denies the question, does not ask it. So there's a science taking hold, a cross-discipline taking hold, and these reforms, if they are to continue, in other state Supreme Courts changing their rules, and by the way, except I think in 5 states, it's committed to the sound discretion of the individual trial judge in 45 states, whether that judge will allow jurors to ask questions, take notes, sound discretion of the trial judge. These are there for trial judges to read and see, and for lawyers to make arguments. Judge, this is a complex case involving patent and engineering principles. I think a jury ought to be allowed to ask questions in this case, Judge. I know you haven't done it ever before in your courtroom, but we have some research that we think our client is going to have a better chance of making its case if we have an educated jury in this patent case. This is the kind of thing that these principles serve, that the empirical research that's going on is serving. And those of you who are going back to your law firms, back to your classrooms in your law schools, look at this, because you can really help your clients by digging in and getting some facts instead of, we've never done it this way. It will never work. You need more than that.
Thank you, Judge Mize. Turning it over to you all, to the audience, to see if anybody has any questions. And the first hand I see is Judge Urbina. So please go ahead.
Well, it's more of an observation than a question. I certainly can understand how Mr. Patterson, like many, many, many attorneys, and judges, by the way, would have reservations about letting the jury participate or getting the jury actively involved in the trial. But I wanted to put a couple of notions to rest. First of all, there is an instruction that is given by the trial judge before the opening statement, which specifically addresses this issue of asking questions. It's a very comprehensive instruction, as Judge Mize has already implied. It tells the jury, we do not encourage you to ask questions. That's a quote. The court is not encouraging you to ask questions. That's one thing it says. Then the instruction says, if you have a question, often, if you're patient, you will learn the answer to the question throughout the course of the trial, and therefore you will not retire into deliberations without knowing or understanding the point. The third thing is that when at the end of redirect, when the juror holds up or the jurors hold up their note, and that note is taken by the judge, my understanding of how other judges do it, and I'll tell you, however, how I do it, is that I read the note, the lawyers come to the bench, they read the question, and if either side objects, I don't ask the question. Rarely have I had lawyers object to the question, because both sides, by that time, want to know the answer to the question, one. Number two, it gives the lawyers some insight into what the jury is thinking about and what the jury might think is important. Number three, of course, it may illuminate something that, as I said earlier, that the lawyers have missed. Number four, one of the big problems, one of the nightmares that judges have are hung juries. Not infrequently do juries hang because there is a mutual lack of understanding on two or more jurors' parts as to what something means. Not infrequently, during a trial, a juror or two will ask a question that will then illuminate that point, factually or otherwise, and that reduces the prospect of a hung jury. Next point, it does not elongate the length of the trial. If anything, it shortens the length of the trial, because once the lawyers get an inkling of where this jury is going, what they're thinking, they reconstruct what it is they want to present. Also, this business of answering a question or not answering a question, letting the jury know, for example, many questions are asked that are inappropriate, and the judge tells them that. But answering the question kind of gives the lawyers a chance to restructure and to redirect where they're going, and frequently that creates more economy, not more wasted time. Therefore, I don't think there's any delay in the proceeding. The questions, the introductory instructions, really, if you read them, and I think this jurisdiction, District of Columbia, has extraordinary instructions on this point. It's about 2 or 3 pages, and the instructions were developed and drafted by lawyers, prosecutors, defense lawyers, plaintiffs' lawyers, defendants' lawyers, so that the jurors have a pretty clear understanding of what it is that they're being told they can do during the trial, such as ask questions. So I would not want any lawyer here or other person to walk off without understanding that not only are Mr. Patterson and Judge Mize correct in suggesting that you would need to look at the book and see what the suggestions actually mean, but also I think as important as that is actually reading the instruction that lets the jury know that it can ask questions. In an average trial, I'd say if I have 6 questions that are asked during a trial of a week or two, that's probably the limit of what I can expect the jury will ask. So I agree that the perception of it may be, my goodness, you start letting jurors get involved, they're going to take over, they're going to say things, they're going to do things, they're going to demand things, they're going to intrude on the province, each other's province and the province of the court. It doesn't happen, and I have 16 years of experience to confirm that.
Thank you, Judge. Any other questions from the audience? We have a little bit of time. Gentleman in the front here on the right, on my right.
Yes, hi. I wanted to talk about the juror's right to serve. I have lived in the Washington area since 1973, and I'm going to be 65 in February. I have never served on a jury, but I wanted to serve on a jury. I was impaneled in Arlington County, and I was called to question 6 times. I was rejected each time. I asked the prosecutor on one occasion why I was rejected, and she said, well, you're a lawyer, and secondly, you work for the Lawyers Committee for Civil Rights under law, so I rejected you. I talked to the clerk of the court, and I said, what is going on there? And he says, oh, well, you should have talked to me before, because if you're a lawyer or a doctor, you automatically can be excused. Now, I'd like folks to comment on whether or not under today's law, or whether you think it is appropriate to exclude all doctors and lawyers from jury service, how that can conceivably be a jury of your peers, particularly in a place like Arlington County where there are a lot of doctors and lawyers.
Judge Mize?
The ABA principles speak to this and cite what's been done in jurisdictions. The recommendation is that a citizen's right to serve ought not be infringed. And there are two big goals of jury selection: representative, which the Supreme Court has told us must be accomplished, and number two, inclusiveness. And one of the things that has stood in the way of inclusiveness, of having the largest segment of the eligible population eligible to serve, is to eliminate professional exemptions. Chief Judge Kaye in New York, the Chief Justice of the Supreme Court is called the Chief Judge. During her administration, she took seriously the barriers to jury service that the legislature in Albany created. If you wanted to get out of jury service, as long as you belong to a very well-lobbied professional association, you would get out. And New York had something like 25 professional exemptions. And she was able to convince Albany to repeal all of them and rely on jury selection, rely on the Q&A that occurs between judge and citizen, between lawyers and citizen. Find out if this particular lawyer who has a big case coming up is going to be so distracted that he can't serve. But we don't start out with the proposition in New York, and now in most states, as more and more states have followed that policy suggestion, and professional exemptions are being repealed repeatedly in the last 20 years. By eliminating those exemptions, everybody starts out, one, being subject to being summoned, and number two, once summoned and showing up in the courthouse, being eliminated or rejected for jury service for a reason other than your occupation. And so it's a very important principle, one of the best practices mentioned in the ABA document.
Any other questions? Gentleman in, is that a blue shirt, a gray shirt?
Hi, thank you. I had a quick question about Batson and kind of the post-Batson world that we live in. One of the issues that Batson arose, and it's in the dissent there, is that it's quite hard after the fact to question the reason that is given for excluding any particular potential juror. So excluding the case that you have an extremely inartful prosecutor or defense lawyer who says, I'm excluding this person on the basis of their minority status. Are there any other sort of proposals for ex-ante regulation of this? Because ex-post challenges of it have such a high evidentiary bar, and they're very difficult to litigate. Are there any proposals out there that propose a different solution?
Mr. Addario, would you take that?
Yeah. And certainly you're right. It is quite difficult to litigate these cases, although there are things that we can look to determine whether someone was struck on the basis of race, even though other reasons might be given. There's frequently courts look to disparate treatment as to whether there's a white juror who served who had a similar characteristic. And there are a number of other factors, whether the prosecutor actually asked questions about the thing that they claim to be interested in striking this person on the basis of. So there are things that we can look to, and it isn't impossible to litigate these cases. But you're right, it is difficult to get behind somebody's true intentions, especially as you can become quite sophisticated at trying to hide that. And so, some courts have talked about eliminating peremptory strikes. The Supreme Court in Mississippi actually has said, you know what, this continues to be a problem in our state, and if lawyers don't get better, we're going to get rid of peremptory strikes. And so that's certainly something that people have talked about. In Alabama, we have a huge number of peremptory strikes in most cases. We have what's called the strike down system. where you start with maybe 100 jurors and you alternate strikes, defense, prosecution, down to get your 12 jurors. So because you have so many strikes, that creates a real opportunity for discrimination. So limiting the number of peremptory strikes, if you're not going to get rid of them altogether, I think would be another option. And then trying to hold prosecutors accountable more in the community, looking at statistics across the board. I think those are some other possibilities. But certainly it is a difficult problem, and I think we do need to think of creative solutions.
I'm looking at the clock, and I think I'm supposed to be wrapping this up, or maybe we're even beyond time. So let me just ask the panelists if they have any closing remarks before we close the panel on any of the topics that were raised. Anything that you briefly want to share with the audience that you haven't had a chance to do. So let me start with Professor Ferguson.
Sure, just briefly, I would say that the idea and principle of jury engagement isn't simply for judges, although I appreciate and understand why chief judges might send the marshals out to get people. But it's not just about judges to get jurors into their courts. It's not just about lawyers who need juries, and not in the ABA, I'm a proud ABA member, but it's not just them, it's really you and people like you. The Constitution starts with we the people, and the idea to get citizens engaged in juries is we the people. We have to do it, and we have to talk to our loved ones and our friends and our family about the importance of it, and actually see it for yourself. I'm sure many of you still doubt the idea of, well, yes, I understand, in principle it's a wonderful constitutional thing, but how does it really matter? And to actually see that it does matter. It matters to the lives and liberty of people who are there. It matters to the system of democracy, and in a world where we are not as engaged as we should be in constitutional principles. And it makes the Constitution come alive at least every once in a while when you get summoned down to the courthouse and you have to spend a day being a citizen. So it is about we the people, and it's about you.
Thank you. Mr. Patterson, any final thoughts?
Well, I agree with Mr. Ferguson's comments. I mean, the system of justice in the United States is, I believe, the best system of justice in the world, and a major component of that, if not the major component, is the jury system, but it's also based in the other constitutional protections that we have, the exclusionary rule as to evidence that was improperly obtained to not allow it into court as into evidence is another major component. But the jury system is obviously the linchpin of how the system works. It's a system to be protected, to be revered. I agree with Judge Mize. It doesn't necessarily have to be stale. There are obviously better ways to do it. A lot of those ways are taking place, have been taking place, such as note-taking and giving the written instructions to the juries, things that didn't happen 10, 15 years ago that are changing. So the fact that we can get together, examine it, talk about it, explore different avenues and weigh ideas to improve the system is a good thing, because while we have the best system, doesn't mean that we can't make it a better system than it is already.
Thank you. Judge Mize?
We have some guests from Korea in the audience that I had the pleasure of meeting with earlier today, judges who are here to study our trial by jury, and it's another indication of what a jewel we have in this country that needs to be shined and shown as much as possible. And welcome again. And lastly, Judge Urbina and I were at a conference a couple years ago, and we heard a judge, I believe he was from Texas, who tells his jurors in every jury trial at the beginning of jury selection, if you're selected in this jury, you should, and for this case, you should make sure you put it on your resume that I helped administer justice. Not too many people in this country help administer justice in a real case, and you did it. That's a nice thought.
Thank you. And last but not least, Ms. Addario.
I just want to thank ACS for organizing this panel and my co-panelists. It's been a really interesting discussion, and I do think jury service is critically important. It's something that is really the bulwark against abuse of power in the justice system in many ways. And so I think this is a really important conversation, and thank you.
Thank you. Thank you to ACS. We're going to go ahead and close the panel. Thanks to all our wonderful panelists and to Judge Urbina. And I think that is it.